This a big up, this one's for Greg. Straight from the rain and every Jimmy and Red. Him a reggae lover, the real Dan Dada. Pinny this champ and the bike.
A Day at Trust Class. Author, Bard, Justis. Chapter 1. A Unique Kind of Trust. It was an unusually focused morning in Miss Hamilton's class as she announced the day's topic, the powerful and often misunderstood world of express trusts. Today, they would discuss a type of trust structured under the American common law based on the principles outlined in WEISS'S Concise Trustee Handbook. Good morning, everyone, Miss Hamilton greeted the class. Today we're diving into a unique kind of trust, the express trust. This trust operates under the common law and avoids statutory oversight. It's a special setup for people who want their property managed privately, within a natural legal framework not dependent on government permissions. It's a world that's a bit different from what you might expect. Now, who can tell me what a trust generally involves?
Jamie raised her hand. A trust is when someone holds property for someone else, right? Yes, exactly, Miss Hamilton nodded. At its most basic, a trust involves one person, the trustee, holding property for the benefit of another, the beneficiary. The person who sets up the trust is the settler. But unlike standard setups, the express trust functions as a superior form of security for those who desire to exercise their natural rights. Weiss uses this term because express trusts protect property from outside interference when they're structured correctly. Footnote 10, for example, emphasizes that these trusts are designed to preserve natural rights, especially the right to contract, without government intervention. Chapter 2. Understanding the Foundations. Miss Hamilton continued. To understand express trusts, you need a little context on the general law merchant, she said, noting the student's blank expressions. In footnote 1, Weiss explains that the general law merchant is a common law system that governs commercial transactions and has been in place in the US for centuries. It essentially means that business and property transactions can happen without government interference, except in specific cases. This merchant law gives express trusts their distinct strength, operating on common law rather than civil law, where the government's role is minimal. Tom looked intrigued. So, this means the trust operates independently? Exactly, Tom. Under the general law merchant, the express trust operates independently. In fact, Weiss explains in footnote 6 that it was common for these trusts to be formed without needing special permission. This independence allows for a much wider range of actions. For example, trustees can issue certificates of beneficial interest, divide the trust property into shares, and even take on bonds. Essentially, they have the flexibility to manage the trust like a business without being restricted by typical corporation rules. Fascinating, right? The students murmured in agreement. Chapter 3. The Declaration of Trust. Let's get to the heart of the express trust, the Declaration of Trust, Miss Hamilton continued. The declaration is the formal document where the settler clearly defines the purpose, property, and rules of the trust. Footnote 15 notes that a trust declaration doesn't need technical legal language as long as the intent to create the trust is clear, it's valid. This simplicity is key to protecting the trust's independence. Rachel raised her hand. So the declaration is just the trust's rules then? Exactly, Rachel. It's the rule book, but with weight. Footnote 18 explains that every detail in the declaration matters, especially for express trusts, because if any part is unclear, the courts might need to interpret it. And when a court steps in, they can sometimes alter the trust's original purpose. That's why, as Weiss puts it, everything must be unambiguous, so there's no room for outside interpretation.
Miss Hamilton paused to let the importance sink in. Think about it. The trust declaration creates a contractual relationship, but it's more than just words on paper. It establishes an independent legal entity that can own property
engage in transactions, and carry its own legal rights and responsibilities. It's as close to a person as a legal entity can get. Chapter 4. Trustee Powers and Fiduciary Duties. Turning to the board, Miss Hamilton wrote Trustee Powers and Fiduciary Duties. Now let's talk about the trustee who manages the trust's property. Trustees in an express trust have considerable freedom, but they must act in the beneficiary's best interests. Weiss mentions in footnote 61 that trustees in express trusts have three main types of powers: general, special, and discretionary. Jamie looked curious. What's the difference between these powers? Miss Hamilton nodded. Good question. Let's break it down to general powers. Allow the trustee to do things like pay taxes and maintain property. Special powers might give the trustee specific authority to sell, lease, or make decisions about the trust property. Discretionary powers give the trustee flexibility, allowing them to act as they see fit within the trust's purpose. But here's the catch. With great power comes great responsibility. Footnote 69 emphasizes that trustees are under fiduciary duty, which means they're legally bound to act solely in the beneficiary's best interests. They can't misuse their power or act for personal gain. If they breach this duty, they can be held personally liable. Tom raised his hand again. But what if a trustee oversteps their power? That's where the trust declaration acts as a safeguard, Miss Hamilton replied. The declaration sets clear boundaries, and if a trustee crosses those, the beneficiaries can seek legal action. In express trusts, this setup gives the beneficiaries an extra layer of protection. The trust is managed independently but not without accountability. Chapter 5. Transferring Property and Protecting the Trust. Miss Hamilton moved to a new section. Once the trust is created, the settlor must transfer property into it. This transfer makes the trustee the legal owner, but only in their role as trustee. Footnote 29 highlights that this property transfer is essential because without it, the trust can't function as a separate entity. Alex raised his hand. But if the trustee is the legal owner, what happens to the beneficiary's control?
Great question, Alex, Miss Hamilton said. That's the beauty of the express trust. The trustee holds legal title, which means they have control of the property, but only for managing it in the beneficiary's best interests. Beneficiaries hold what's called an equitable title. They're entitled to the benefits of the property, but not its management. Footnote 9 clarifies this by explaining that beneficiaries' rights come from their relationship to the trust, not from direct ownership. Miss Hamilton paused. This structure is powerful because it keeps the property out of reach from outside interference. For example, in footnote 13, Weiss notes that the express trust, when properly created, enjoys a superior form of security, meaning it's harder for creditors or third parties to interfere with the trust's assets. Essentially, the property is shielded, creating a solid foundation for the beneficiary's future. Chapter 6. Certificates and Legal Flexibility. Now here's something unusual about express trusts, Miss Hamilton continued, gaining the student's attention. Unlike standard trusts, an express trust can issue certificates of beneficial interest, which means it can divide the trust property into shares. Footnote 34 explains that this is one reason the express trust often resembles a corporation, but with a critical difference. It's still not governed by corporate law. Instead, it retains its private, contractual nature. Rachel raised her hand again. So express trusts can act like companies without being companies. Exactly, Rachel, Miss Hamilton nodded. Footnote 37 highlights this flexibility. The express trust can issue shares, limit liability, and even use an official seal, privileges we often associate with corporations. But since it's a private arrangement, it doesn't need a corporate charter or government approval. This freedom is why express trusts were so popular historically for holding assets and even running businesses. Chapter 7. historical roots and natural rights. Miss Hamilton could see the students were absorbed. "Let's talk about where express trusts come from," she said. Footnote 8 offers a fascinating insight. Express trusts trace back to common law, designed as a way for individuals to protect their property rights without interference. Weiss even references Supreme Court Chief Justice Warren Burger in footnote 2, who pointed out that a significant percentage of trial lawyers often misunderstand or misuse legal structures. Express trusts were created as a way to avoid this, allowing people to manage property independently. Tom raised his hand. "So it's like a system to protect your property?" "Yes, exactly," Miss Hamilton replied. "Express trusts grew out of the need to secure property rights, and what's unique, as footnote 20 emphasizes, is that equity, the legal principle ensuring fairness, compels the trust's performance. That means that if the trust is legally established, it has full legal support to operate without interference. It's a powerful concept that ensures express trusts retain their independence and protections under common law." Chapter 8. Final thoughts on express trusts. Miss Hamilton wrapped up. Express trusts might sound complex, but they're grounded in a simple idea: securing property rights and keeping management independent. Today you've learned how the declaration, trustee powers, and equitable titles combine to create this unique legal structure. Each element, as Weiss explains, helps preserve natural rights, making the express trust a powerful tool for anyone wanting to manage property privately and responsibly. Jamie raised her hand, her face lit with understanding. "So the express trust really is like its own person?" Miss Hamilton smiled. "Yes, Jamie, you've got it. Footnote 22 even describes the express trust as having its own juridical personality, meaning it's seen as its own entity in the eyes of the law. It can hold property, enter contracts, and protect its assets. This gives it a unique strength, making it a valuable option for those who value privacy and independence. Chapter 9. Reflections. As the class packed up, Miss Hamilton felt a sense of accomplishment. Today they'd tackled some of the most complex ideas around property law and rights. The students left with a newfound appreciation for the structure and power of express trusts, knowing that, through understanding Weiss's insights, they'd uncovered a unique legal tool that had stood the test of time.
Discipline and faith that is consistent, tilling up the soil for the fruit to be abundant, seeking out the wisdom, always be a student, watering the root and bringing forth the remnant. Now who you want to be, which choices will you make? The path of destiny are the choices that we take, and you can start again, and now you're in the wake. Keep intact your vessel and clear the muddy lake. The wise will recognize, realize, prioritize. Get your mind in order, you have to supervise. Vigilant with love, we have to synthesize. Now wise as a serpent, loving is the prize. So daily discipline and faith that is consistent, tilling up the soil for the fruit to be abundant, seeking out the wisdom, always be a student, watering the root